All right, my name is Andy Duggan. I work for the Spokane County Prosecuting Attorney's Office. I think I'm on my 23rd year. I'm on my second tour in juvenile. I do criminal prosecution, generally around the gang-affiliated youth, as well as all of the truancy cases. And we are one of the counties that is actively using the truancy process to try and re-engage a lot of youth who disengaged over the pandemic. So it's been crazy, but I'm here. If you were here last year, this is a lot of repeat, but there's also new additions. And then based on some of the questions from last year, I added some stuff in. It's a lot of material, so I'm gonna kind of move quickly because I ran out of time last year. I am chatty, but if you have a question, please ask. So basically, I have a diverse group in here. We do have SROs, we have the SSOs, and any other school specialist designations. There is a distinction legally between a law enforcement officer who's assigned to a school, who's an SRO. They are given arrest powers. They do lots of different things regarding crime, disorder problems, gang, drug activity. The focus right now is generally to keep the students out of the criminal justice system. I can tell you in Spokane, we do have some of our larger school districts who have opted to remove the SROs from their schools and have implemented, I think, school security specialists, which fall more in line with their non-commissioned safety and security, violations of school policy, as well as discipline, no ability to arrest. And unfortunately, the trend we've seen, or fortunately, but it's leading to an unfortunate result, is there's been a big push to keep what's happening in school in the schools and out of the criminal justice system, which is not necessarily a bad thing unless and until it hits some breaking points. And our school districts are facing that. Our largest one is facing it with a lot of problems. So my word of caution is that I think you've got to have a relationship with law enforcement to keep your school safe and to maintain some semblance of order. We have school districts who have literally abandoned law enforcement and law enforcement participation. We have assaults going on that go unreported. Even if the victim, student, or family want charges pressed, they are required to contact law enforcement. Generally, it's the parent who doesn't know enough information, so investigations never happen. It's after the fact. I think every school district's dealing with what's going on in the bathrooms and that whole entire situation. So I think the move away from the criminal justice system was with, in general, good intent, but it's leading to some very unstable and somewhat scary occurrences within the school setting. I have tons of kids on truancy who use that as an excuse or a justification for not going. It's not safe. I don't want to be jumped, going to the bathroom, all sorts of stuff. So these roles are really important. I just hope you're in school districts that are, at least if you're not using SROs, allowing some meaningful communication with law enforcement. It's got to be a team effort with these schools. So I'm going to cover the basics of search and seizure. I'm going to go over the SSO, SRO comparisons. I'm going to go over a new seizure case that came out. Go over the interviewing of juveniles and the statutes with recording and a right to attorney, the interrogations, the drug laws, and then some legislation that's still out there. Search and seizure. Just so you know, school officials have an exception to the warrant requirement based upon the need to maintain safety and discipline in schools. They are not required to obtain warrants. They are able to seize and search certain aspects. I can tell all of you, because somebody is taking a picture and I don't mind, they're going to share this presentation. If you want it, they'll email it to you. I have no problems with that. But the basis for it is schools need to act swiftly to maintain safety, swiftly to maintain discipline. State versus McNeese came out, and commissioned law enforcement officers, SROs, are not going to fall within that category. And there's a distinction between a law enforcement officer and a school official. One is for the safety and orderly function of the school. The other is for law enforcement duties. So just understand there's a distinction and it matters. This screen, I love the background, so I didn't give it up. So a school principal, vice principal, or a designee is a school official. All they need is reasonable grounds to believe that a search will yield evidence that the student has either violated the law, criminal, or school rules. Mandatory if you believe there's a firearm, and we'll get to that in a second. The scope of the search is basically, once you have the reasonable grounds to search, whatever you're searching needs to be reasonably related to it and not excessive. So, for instance, and I go down below, who is your school official, principal, vice principal, designee? What can you search? Student's positions, student's locker, student's vehicle. What you can't do are strip searches or body cavity searches. And that's actually prohibited. So in case anyone got some crazy ideas, or you have somebody who got crazy ideas, you need to say no. My word of caution on vehicles is, and I'll get to it, is make sure there's a connection. Firearms. Is anyone else getting the threats to shoot up the schools, the threats to bomb the schools? This is crazy. I feel for school districts. I somewhat feel for these kids a little bit, because some of them, it's just idiotic, but then are you going to be the one to take the chance that the kid didn't mean it, and the resources that are being expended? But just know, if anyone says somebody has a gun, you've got to look for it. I don't think that anyone wouldn't, but I'm just saying that this is a specific requirement. What's strange, though, is that it's only a firearm. So other dangerous weapons don't count, but I think the school policies would kick in, and you're going to do the search for those. But just, this is a recognized requirement if there's a concern over a firearm. It doesn't include the airsoft guns, Nerf guns, pellet guns, but in this day and age, it's very rare for you to know which one it is. So as long as it's going to fall within the possibility of being a firearm, you've got to do the search. Okay. Reasonable belief that a student is in possession of prohibited item or evidence in violation of the law or school. We just went over that. Here are some cases. State versus AS. It's kind of a strange case. A middle schooler was threatening another middle schooler, showed up at that other middle school. I shouldn't say that. Student goes to a different school, threatens a middle schooler, goes to that middle schooler school. They contact that student because they pulled it up on the district site to get a picture, pull her into the office. She smells like marijuana, and they do a search, they find it. Long story short, the question was, did this apply to a non-student? Because the student didn't belong to that school. The court didn't answer that question. What the court found was that the smell of marijuana emanating was not sufficient reasonable grounds. So they relied on the reasonable belief, because again, we had a student that was a threat, not a student with drugs. Seems a little odd to me if they smelled the marijuana, but so they hung their hat on the fact that a reasonable ground was not just the smell. They didn't address whether you could conduct a search of a non-student on the premises. So it's a little bit out there on that, but definitely for students, and they didn't prohibit it if you have a student from another school on your premises. They didn't say you couldn't. Then the McKinnon factors play into this as to what's reasonable. And they use this a little bit in AS. What's the student's age, discipline history, school records? Obviously, it was a student that didn't belong at that school, so they didn't have any of number one. How serious was the problem that was being addressed by the school? The school didn't provide evidence of a drug problem. In fact, the school said they didn't really have one, so they used that against the school. The exigency of a search warrant requirement, they had already called law enforcement, so there was a concern there that there was no reason for it. So again, you sort of got to think about how you're presenting this as to as to why it's reasonable to search for what you're searching on that student and whatever their possessions are. The good news that is for schools is that the confidential informant or anonymous tip or unidentified student information is sufficient to justify a reasonable belief. And that's pretty well, I cited the bottom case. It's unpublished, but it's again a student saying someone had a vape pen. The school is free to rely on that, and that's reasonable. So the good news is it doesn't necessarily take a lot when it's a student, I guess, telling on another student. You don't need to do a lot of corroboration. You can use that. No random searches. And I've had this come up recently. So there are school districts, and I completely understand this, who allow for, if they have students who they've have a disciplinary history with or some history of noncompliance, they have implemented random searches of the students' backpacks. And I can understand why. If they brought weapons to school before, maybe as a school policy, you're saying, we don't trust you, so we're gonna do these random searches. You won't know when they are, and blah, blah, blah. And that's fine as a school policy. Just know that for criminal charging, that will not stand. Like, we cannot use it to prosecute because you can't have a random search. This goes back to also and I think it'll come up in a case where a student left the closed campus and returned, and the school district had a policy that if you returned after leaving campus without permission, they automatically searched your bag. That's random. There's no basis to believe they had violated the law, or you were gonna find evidence of them leaving the closed campus. So again, it's got to be a reasonable search. It can't be random. And really the ones that I've seen recently are the ones where there's security concerns for the school districts, and they have implemented policies that have a random search aspect. And I understand why they do, and I'm not criticizing it, but just from the criminal perspective, we can't prosecute it. If you had reason to believe they brought a weapon, aside from the fact that they brought them in the past and you're doing a random check, it's a different story. But if it's just, oh, I got a hand in the back.
If it's written into a behavior plan and can you use it if it's written into a behavior plan with a random search and you do find something?
No.
You can't use that either?
No, not criminally. And again, it's gonna go back to, it's not about the student's agreement to do it. It's about the school's use of that exception to get to it. So it's all going to come back to, it's got to be a reasonable ground in that specific situation. It can't be an agreement. Does that make sense?
Even if the parent signs off on
Yes. Yes. Mm-hmm. And again, I understand why they have these. I'm not disagreeing with them. Just understand it limits the prosecution of the juvenile. Okay, school officials must have a reasonable belief that, again, the student is in possession of a prohibited item or there is evidence of a law violation or a violation of school rule. Again, the area has to be related to what you're seeking, and the search cannot be excessively intrusive. So the examples that I gave are State versus BAS. This is the closed campus case I was telling you about. Left campus, came back. They did a search of the student and the backpack based on the violation of the closed campus rule. No reasonable belief that the student was carrying something illegal or that there would be evidence of the closed campus violation. So it's unreasonable to do that. School official believing that the student had drugs in violation of school policy. Again, this one's pretty basic. If you have reasonable grounds, and it can be another student saying that, yes to the outer clothing pockets, yes to the backpack, no to underwear. A knife in a vehicle occupied by 2 students was seen. Yes to the students, yes to the vehicle. what I couldn't tell in that case is whether they never identify who the vehicle belonged to, but the two males were in the vehicle with the knife. And I think that helps, is that when they saw the knife, the juveniles were in the car with it. I don't know how it plays out. Like I said, the cars are a little more interesting, but in this case, the juveniles were in the car, or the students. Yes?
What's the definition of a strip search?
You know,
And I
it's kind-
ask that because
kind of scary.
we've asked kids that might have like shorts underneath their pants to take their pants down, but not their drawers, the shorts that they're wearing, because they might have stuff in their pockets in their gym shorts that they're wearing.
So you're talking 2 layers of clothing.
Yes.
I think you're okay on all of that. You can't get to the underwear. So if they've got sweatpants and shorts on and you want to see if there's something in the short pockets, I think you're okay with that, because
Okay.
that's outer. Oh, yes.
Kind of going on what he said, if we have belief or we know that they have hidden something in their arguments, how do we go about to get approval to search that?
Search warrant. Yeah. Yeah. There's some, in theory, you might be able to do some type of search consent. And we're going to get to that because you're going to have to put the juvenile in contact with an attorney before you do that. And so that is a route you could go if you wanted them to consent to that. I'm assuming we've all used the number to call the defense attorney for the juvenile, and I can tell you what their answer is going to be. But you could, you could attempt that, but you need to put them in touch with an attorney. Best case scenario is to get a warrant. If you have cooperative parents, you could call the parents, and the parents could assist in that. They have more. They can't be your agent, but you can say, I have concerns that there's drugs being hidden, and they can act as parents to do what they believe is appropriate in locating them. Lockers. Lockers are free zones for searches as long as you're a school official. There's no reasonable expectation. Okay, older case that says the fact that. Okay. McKinnon is an interesting case because the concern came from, I think it was a police chief. He had called to let the school know, hey, I'm getting information that such and such student, I can't remember if it was a weapon or drugs, and this was held, and the school did a search of the backpack, the student, the locker, found drugs, so forth and so on. And this was upheld even though the information came from law enforcement and that the school was responding to it. Now, here's how I think you have to be a little bit careful. In this situation, the law enforcement officer called just to say, hey, I'm giving you a heads up. I think it was drugs, if I remember right. I'm giving you a heads up. This kid might be dealing in your school. So the school took action to prevent that from happening, if that makes sense. If a police chief calls up a school and says, hey, I think this kid's dealing drugs, will you check it out and get back to me? That's going to be a whole complicated issue you don't want to go into. So if you're a law enforcement officer and you're trying to convey information to a school, make sure you're not requesting them to do anything, inviting them to do anything, because they can become your agent much more easily that way. Schools are smart. They're going to look into these things. They don't need that additional push necessarily. And if they do need that additional push, they're probably going to tell everyone you told them to do it, and then you're going to be the one having to justify that. So it just doesn't play well if you have to tell a school, go look for it. And I get it. There's some schools right now who aren't looking, but we won't be able to salvage it. Oh, I apologize.
Question. It's fine. Before I forget, the random searches, going back,
Yeah.
we've got some, I guess, some policy in our school that they've, as soon as they've identified certain subjects belonging to a particular gang, per se, for safety reasons. We had a shooting out just a block away from one of our schools, and we've identified 2 of the shooters as 2 high school members. One who didn't go back to school, the other one was going back to school. So they decided, okay, we're going to implement this policy that says we're going to be able to search you every day. But when you come in, you're going to come in, report to one of the administrators, and you're going to they're going to be able to search your backpack, make sure you have nothing. And this is done on a daily basis type thing. So if it's not a random and it's an everyday type thing, the judge, I think it was Rukov here in Yakima County, found out about it and gave the school some lip service, saying that it was unconstitutional.
It's
but
not,
if it's-
it is and it isn't, because it depends on what you're doing. I mean, the problem for schools is that you're not necessarily doing this just for criminal prosecution. You're doing it for the safety of the students.
Right.
And so that's the difference. The idea is not that schools can't do these things, it's that we're not going to be able to prosecute it criminally.
Even
And
if
that-
it is on a regular
Yeah.
basis, and because
Yeah.
they try to push random, and I said, no, let's keep this an everyday type thing.
What
And-
has to be, let me go back really quick. The reasonable belief has to be tied to the search. It can't be based on something in the past. It has to be tied to why today do I believe I may find something in this backpack. And that's the problem with it, is that it's got to be to whatever you're searching at that moment. Because the exception, if you think about it, the exception is I'm running a school, I have to respond quickly if I have a belief that a student has something. And the problem is you don't have the belief that they have something that day, but you have concerns that they might because of their past behavior. And that's just not going to be enough to get past the criminal side of it. Does that make sense?
Yeah.
Okay. It's not ideal, and I don't think schools need to change. It limits what we can do. Yes?
Talking about the criminal, do the schools still have the burden of proof? Say, even though they can't bring them up on criminal charges, can they suspend them
Yes.
and/or expel them? Without having the burden of proof?
Well, you can emergency expel, and then there's rules as to what you have to do when you go down that process of an emergency expulsion. There are due process rights that will apply to the student, and the school district should have that all outlined. I know, the initial can be 3 days of an emergency expulsion, and then it can be extended. They do have a right to due process, which is some notice of what the allegations are. And I believe if in the end they want to challenge it, you have to have something available for them to be able to challenge it. However, having said that, a number of the emergency expulsions I've seen on the truancy side, I've not seen anyone really challenge it, because generally there's limited situations where a school can actually do that. And so by the time they're at that point, it's generally not contested. It's just kind of how long. And if not, and just so you know, if they expel them, they have to still provide an education. So there's a lot at play when this happens. But yeah, the school would have a burden in that situation to prove it if the student wanted to contest it, if that makes sense. You get the emergency expulsion for safety reasons, and then the due process would kick in. Yeah.
I just want to clarify that.
Hold on.
So I just want to clarify that schools can do random searches, it just can't be done criminally after that.
Absolutely.
Okay.
Now, I said absolutely. Then my little mind's going, whoa, Andy. Absolutely. I know, write it down. I am presuming in the instances I've heard, there's a pattern of behavior or conduct that is leading to that policy for a specific student. If you're targeting a specific student with random searches, you should have a history that's justifying it. Does that make sense? I also think you can still do the randomness of if you leave the closed campus and come back, we're going to search you. Just know that nothing criminally can come of that, because that's a policy that's not targeting one student, it's any student who violates. I think when you target a specific student, you better have the history to justify whatever it is you're doing to them. And it's not that hard, I don't think, with discipline records, but just so we're clear on that. Yes, I think you can, just make sure your record's good. Okay, so you want to talk to a student. School officials don't have to comply with Miranda. They're free to chat. I'm going to talk about heritage specifically in a minute, so we're going to come back to that. When you have an SRO present, it's a gray area, and I'm going to follow up with you on that. Obviously, if you have an SRO present, and we're gonna get to this, I believe Miranda is gonna kick in on that. And this last year, I added a lot more to this because there were a lot of questions about it. But if it's a school official, they don't have to worry about it. I think the SSOs are gonna fall in the SRO category as well, which a lot of people last year were a little surprised by too. I think outside of the school officials that are non-security officers, non-SROs, I think Miranda's gonna end up applying, especially with the shifts that keep happening with the juvenile area. I just put in a couple of the age factors. A student is under 12, the parent or guardian has to be brought in order for them to waive the right to remain silent. I don't know how many of you are, I think we deal with 12-year-olds. I just don't know if you're doing criminal investigations. In our state, under the age of 12 is presumed to have incapacity. So generally, I don't think you're worrying about criminal charges at that point, but if you are, know that the parent has to be involved, plus the statute for the attorney. It's a lot. If they're over the age of 12, it's just a factor to be considered. Certainly if a 12-year-old wants their parent, you're gonna be hard pressed to do anything other than get them their parent. That just won't look well unless you've got some exigent circumstances. And then the bottom provision is if for whatever reason you're actually investigating the parent for abuse. Yes, they're
Questioning an adult doesn't apply. Like if you don't work with children, but you're working with an adult, would a Miranda still apply if you're an SSO?
If you're dealing, are you investigating the adult for charging purposes?
Either, not necessarily charging purposes, but maybe to identify the situation. Could be like a policy violation or
Okay. What an SSO the same will apply either way. Miranda's going to apply the same way it would apply. I'm going to say yes. But if you're investigating a school policy and not a criminal law, then probable cause isn't going to come into play and Miranda's not going to come into play. If you're looking at criminal charges or the potential for probable cause, then when you start getting into the area where you think a crime has been committed, then you have to start determining when you have PC, or if you're detaining them, telling them they're not free to leave. Does that make sense? And that's an adult or student.
So if you detain them, Miranda.
You can do a Terry stop brief detention without needing to Mirandize if you're investigating. So you have this gray window under a Terry stop that you can detain them for a short period of time with limited questions, basically to alleviate whatever your reasonable suspicion was. So I don't know I don't know what it would be. I'm trying to think. If you think they have, I'm just not going to go into this yet because I'm going to get lost in this one. What I'm saying is you have the Terry stop, which is a brief detention that doesn't require Miranda, to alleviate your concerns, whether somebody's armed or dangerous or the potential for criminal behavior. That window then evolves into probable cause, detention, Miranda. So it's a gray area between then. Yes?
So is he speaking on the fact of the matter of him as a security officer? Hold on a second.
I think he was saying SSO and an adult. So yes. And here, we're going to get to this as to why I think SSOs don't get a free walk on this. And we'll talk about this in a minute, so we'll get there.
Okay.
And, okay, so this is where last year we went over this. There's this old case, 1984, where a court said a school security officer did not have to advise the student of Miranda. And that sort of was what seems to have been like a holding pattern through the 80s and 90s. Heritage came out, it abrogated Wolfer. It didn't overrule it, but basically said it doesn't agree with it. And then it came up with this analysis with regard to security officers. And so looking at this, and we're going to go to heritage in a minute, I think SSOs are going to fall in with city park security officers, and they're going to be required to comply with Miranda. So I think if you're detaining someone as an SSO for criminal behavior, not a violation of school policy, that is not criminal, I think you're going to be in the boat of Miranda. So heritage is this case. So here are the facts. We have 2 city park security officers. They're employed by the city, oh, this is my county, City of Spokane. So they're not school employees, they're not law enforcement employees, but they're city park employees. They are, I think they're in shorts and a t-shirt with a badge that says security officer. They have a duty bag that has a radio, pepper spray. Theirs, I think, had handcuffs, collapsible baton. They see a group of juveniles in an area where illegal activity occurs in a park. One of them appears to be holding a marijuana pipe and smoking. Both officers smell marijuana as they approach. There's a box of Altoids at the feet of one of the juveniles, the one holding the pipe. So they approach this group. Their goal is to ask a few questions and get them on their way. As they approach, one officer says to the kid holding the pipe, whose pipe is it? The kid says, it's not mine. Then they said, okay, well, we're security. We need to get you moving along. At some point, they also make it really clear they can't arrest him. And then they say to the entire group, whose pipe is it? And then they say, we need to move it along. And at one point, this girl says, the pipe's mine. Then they're IDing him to trespass him. The fact pattern's a little unclear as to the timing of all this, but so then they're IDing him to trespass him off from the park for violating the park policies. And they've also requested law enforcement respond. So then they continue to talk with the juveniles to keep him there until the cops come because they can arrest him. So long story short, the analysis, there were 2 issues. Were the park security officers state actors? And they said yes. Officers were wearing uniforms, badges, duty belts, approached the juveniles with authority, asking questions, and their duty did include reporting and investigating criminal behavior. And the statements they used would be used for criminal prosecution. I can't see a way that SSOs won't fall into this because you're generally in a uniform. I haven't seen anyone that doesn't have a badge on. I think you have a duty belt. I mean, it's going to be very difficult to get you out of this category. And you are also responsible not just for violation of school policy, but if you see criminal behavior. And your statements would be used in criminal prosecution. So I think you're going to fall easily under this as an SSO. I can't think of a way. I ran it up my appellate unit too, and they agree. What they did here is that they found that the juvenile was not in custody when she said the pipe's mine. And this goes back to the Terry stop we talked about a minute ago. It was a brief detention, basically to confirm who they were, what they were doing, and move them on their way. This case, the juvenile asked for a special rule that any juvenile would have felt detained because we're kids, and the court said no, that they weren't going to give juveniles their own special detention rule, which I think is huge, too. Because I could see a juvenile feeling much more detained than an adult, but then that gets a little dicey as to figure that out. So I think you're going to end up being under the Miranda warnings, but you still do have the Terry stop ability to detain and dispel your concerns. Did that answer your question?
Yes, and then also to follow up on that, are they gonna have to request an attorney for the juvenile if they end up Miranda?
Yeah, we're gonna get there.
And let me suggest too, this we've had a lot of chatter about this since last year's presentation too. This really helps to clarify it, I think. So in the interest of covering your additional material too, I think the best advice would be to talk to their local folks about this. If they have further questions. I just know this could snowball for us today.
Yes, and I understand that this is not what everyone wants to hear, but I also at last year's training was told that there are jurisdictions where law enforcement basically has an agreement with the SSOs that the SSO does the full investigation so that they, not so that, but and then call us when you've got it all, and then we'll come get them. No, you're a state agent. There's just no way. I get it. I'm like, I don't know what counties you live. I'm trying to figure this out. I know our defense attorneys would be all over that. They just have no use for it. So I'm just being honest with you that I think you fall under this. Given the rule changes too to protect juveniles, I mean, I can't see this turning out well for you to say that somehow you're not required to give Miranda. I'm just being honest with you. There's a hand way in the, I got a couple.
And that's why, is this about this current issue?
Chris is trying to shut it down.
All right.
The searches? Oh, sorry.
So one of the questions I was looking at is you were saying there's a difference in uniform or that you are a representative of the state. So it sounds like they were. I've never worn a uniform in 30 years.
I think that helps the argument if you're not in uniform, but I'm looking around this room right now and I'm just being, I know, I'm being honest. If you're in uniform, because they equate that with an authority. You approached with authority. I'm not saying it wouldn't. I'm just, if you look at it and you look at a park security officer on a bicycle and an SSO, I can't get a distinction that's meaningful.
Okay, we'll take one more question, but if you win a door prize, you have to give it to me.
Okay.
All right.
With searches, you were talking about that earlier. So if they're being viewed as a state agent or whatever in this capacity, and they're the ones that are being used to do the searches, wouldn't they also technically have to get a warrant then as well?
Well, if you go back, if you're the principal's designee, there's an argument that you would fall in this exception, number one. I'm leaning towards no. I'm not sure. I really am not. I just think the more I look at how they're defining, I can tell you if you work at Macy's and you're loss prevention, you're not a state agent. And that's the only case I could find where a security person was deemed not to be a state agent because of that. But in the school situation, because of how discipline and behaviors can easily be criminal, I don't know. The only thing I can tell you is that a Walmart or Macy's store security is not a state agent. Everyone else, I think, is in a gray area. You are employed by a school district too, which is also a branch of a state government. So you just keep falling under these parameters that I get really worried that you're not going to have the ability to do that. Oh, hand up. I don't know if...
I think we're going to have to move on.
Okay. What if you're private? If you're a private security firm? No, private institution. That one I'd want to look into. So if you email them, email me, and I will get you an answer on that, or I'll get it to him and he can share it. I think you have a better argument there, but I'm not sure you're going to win. Okay, so I just am prefacing this. We're losing everything. So, this case came out, and this is for, it just came out. It's rocking the adult side because it's redefining seizure. I'm addressing it here because the same seizure analysis would apply to a student. And it's a little scary. So we're all aware of seizure is generally, the old rules stated, if an objective person in the same situation would have believed they were not free to leave, refuse to request, or otherwise terminate. That's always been it. A reasonable person in the same situation, the same circumstances would feel free to leave. The Supreme Court came out June 9th, and they've switched a word, which is very concerning to me, and they went from would to could. And so what I want you to know is the Supreme Court is now looking at race and ethnicity in determining whether somebody is seized. They will say to you, and I think somewhat true, their position is, we've never had to clarify this, but we want to make sure everyone understands that race and ethnicity are a factor to be considered in whether somebody's seized. Now, here's the problem with the analysis. And again, they don't give a lot of guidance, and so I don't have a lot of guidance to give you. The objective observer, so remember, everything's based on this objective person, is aware of implicit, institutional, unconscious biases in addition to purposeful discrimination, and that these have resulted in disproportionate police contacts, investigative seizures, and use of force against Black, Indigenous, and other people of color. So the case is actually really interesting, and I laid the facts out. So if you're dealing with students who fall into the BIPOC, which is their acronym, it is now a factor to be considered in whether they're seized. And what I can tell you is there's not a lot of guidance on this. So what happened is we had a Pacific Islander who was parked lawfully in a car in front of a church in a high crime area where stolen vehicles had been recovered. It was 9 a.m. The driver appeared passed out. So law enforcement contacts the driver initially because the person's passed out, but also because it's a high crime area, there's reports of stolen vehicles. Looks up before he contacts, runs the car, it shows recently sold, but no date of when it was sold, and it does not come back stolen. So he approaches the window on the driver's side. There's actually a passenger sleeping as well. He has to knock multiple times to arouse the driver. He does not ask either the driver or the passenger once they wake up if they're okay or if they need help. What he says is, "What are you doing here?" To which they said, "Visiting a friend across the street." Law enforcement then says, "Whose car is this?" To which some says, "Why are you asking me that?" And he basically says, "Because there's stolen cars in this area, and I'm wondering what you're doing here." So the defendant, then he asks for a name. The defendant gives a false name. He also says the car's not his, and gives the first name but no last name. So law enforcement doesn't take the ID from the passenger, doesn't have any ID from the driver, goes back to his car and is looking this stuff all up, and the defendant bolts. And then he crashes, and there's a whole bunch of bad stuff. Not a good driver. Okay, so you have law enforcement who sees this vehicle, one person sleeping at the wheel. Then as he approaches, a second person sleeping, takes several seconds to rouse him. And when the defendant does roll down the window, it's just a little bit. And again, the court found that he was seized, and that race and ethnicity played a part in it. The car was lawfully parked. Law enforcement never asked about health concerns. They asked them why they were there, and the court was very clear that indicated that they did not belong there, and that is a racist statement. When they responded, they were there to see a friend. That should have been sufficient. But law enforcement then continued to ask who the car belonged to. And when the defendant asked, "Why are you asking me that?" law enforcement said, "Because I have two men sitting in a vehicle in an area known for stolen vehicles, and you don't seem to know who owns this car." They took that statement and said, clearly he's investigating a stolen vehicle, and he doesn't have reasonable suspicion. So, and then they concluded an objective observer could easily conclude that the defendant was seized. So what I wondered when I read this case is how you know I will say what you say is going to weigh a lot into this. If you're saying you're approaching a car because somebody is passed out at the wheel, you better be asking them if they need help. Are you okay? Because even if once you get there you realize they were just sleeping, you're still justifying the initial contact that you were concerned for their health. The second part of this is that this is really kind of proactive. You know, making contact in a neighborhood to make sure that this car's not stolen. You've had stolen cars there. They are clearly not friendly to proactive. So you're going to have to be able to articulate very, very much so, especially if you have a non-Caucasian, which raises a whole bunch of other federal protection issues too. But I wondered what would happen in a case like taking this analogus to the juveniles in Heritage. If they were minorities, if they were non-Caucasian, would that change the outcome of whether they were detained? And I don't know, because you would have, you know, law enforcement coming up. They did see the pot pipe. Now that wouldn't be a crime. What would be a crime for a minor? So assuming he could say they looked young, you can probably get some initial contact in. But it starts getting harder. The other concern for this is that this objective person, they go on and on about data and statistics and evidence. And what the state argued, and rightfully so, is we have case law that says you're not detained if they didn't take your ID, they didn't tell you weren't free to leave, if they didn't do any of these things, you're not detained. And so that was sort of the argument. None of that happened here. He didn't block them in. He didn't take their ID. He didn't tell them they couldn't leave. And so the response back was, that's great, but that's not enough. So what that means is the case law that we have that basically outlines when someone is detained is not going to get you, is not as clear anymore, because you could have all of that stuff there, meaning no ID taken, no indication that they're detained, and they could still come up with this. And I will tell you that first question probably sealed it. What are you doing here? And I can sort of see why it would just come out. Hey, what are you doing here? And yet that's enough that this started turning into a seizure right away.
At that point in time, had they started, well, they're not going to approach the whole maybe a drug overdose type thing, which would have been my concern, given this day and age. But at that point in time, once you establish that they're okay, hey, you're free to leave at any point. But at this point in time, hey, do you guys have ID type thing? As long as they know and you throw it out there, I think that would have surpassed.
Well, one of the things, because this got brought up, it's circling. So you can talk to your prosecutors, because we're all trying to figure out how you advise people. Because there's a lot of this, it's like a 30-page opinion. And they quote cases and statistics about the disproportionate contact. And they said, you don't have to have that evidence, because that was one of the arguments is, well, we don't have any evidence that this particular law enforcement agency has disproportionate contact with minorities. And they said they're not going to put that burden on anyone to have to provide that we have a history of it. And then, so we thought about that too. Can you just tell them you're not detained? But there's also a point in here where they say the number of questions and how you ask them can lead to a detention. So it's just getting dicier. So I'm just saying, I agree. I think you want to make it clear they're not detained. I'm not going to bet money on that's going to save you on this one at all. And here, which is kind of strange, it was really he gave a false name. And actually the car was his, which is even stranger that he denied it. The car is his. But that kind of played into this too, is like, look how uncomfortable he was. He couldn't even be honest that the car was his because he was so afraid of the contact. So the dynamic at play here is much more, oh shoot, I just lost the word. It's moving. It's going to be gray, and the more you can articulate, the better. What concerns me is the could, because, it's that question, could someone do this or would someone do this? I mean, it's a lot easier to get a could than a would. And so just be aware it's out there. And if you're dealing with juveniles who are in this, either Black, Indigenous, or people of other color, you need to be very cognizant of the basis for the contact and how you're questioning them, because their perception of you plays into it. Meaning if, we have a long history of disproportionate arrests and seizures, that's going to get brought up. And it's also going to get brought up after the fact, which is so hard in some of these situations, which is why we liked the rules. Well, if you don't take the ID, if you don't detain them, if you don't block their car in, those were easier. They were concrete ways to make sure that you weren't detaining somebody unintentionally. And they're gone. So the detention is a lot more, they're saying it's objective, but it's a lot more subjective. So just be aware of that.
10 minutes.
Okay. Okay. So these were some of the takeaways. Weight and ethnicity are part of it. Law enforcement's ethnicity doesn't matter. That was brought up in the case because they never got law enforcement's ethnicity and they said they didn't care. Yeah, so all of these factors that used to be controlling, because there was one officer, not multiple cars, no sirens, no lights, no blocking, none of that is determinative. And then they use the GR 37 rule, which is the new rule for jury selection, where, again, they're addressing implicit institutionalized bias. And now if you attempt to remove Black, Indigenous, or a person of color, the standard changed to could a reasonable person view this as based on race or ethnicity? And I will tell you we've lost. I've personally lost on this when I used it. And the word on the street, and the Supreme Court specifically looked to GR 37 for guidance for prosecutors, is don't even try. It doesn't matter what they say, don't try. And so if that's where we're at on jury selection, and that's the guiding principle for the Supreme Court now, I'd just be very careful. Attorney pleas. Okay, so let's say you've got the kiddo. We have seen a huge number of law enforcement officers sort of freak out when it's a juvenile. Okay, so take a deep breath. We don't need to do that. I have them not being documented in police reports because they don't want to talk to them. They don't want to do anything with them. And, this is very specific. If you are asking a juvenile to waive their constitutional rights, so back to searches, I think you have stuff in your bra. Just give it to me. No. You can't do that under this without putting them in touch with an attorney. But outside of that, it's a juvenile custodial interrogation. You have probable cause to believe they've committed a crime, or you ask them to waive consent to search. So these are the only times this rule applies. So if you are detaining a juvenile, and we're going to go back to that whole seizure case that just came out, that's a lot grayer now on whether you've detained him for purposes of being in custody. If they're detained in custody, if you have probable cause to arrest, you have to put them in touch with an attorney before they can waive their rights. If you're asking them to consent to search, you have to put them in touch with an attorney. What it does not say is you cannot speak to a juvenile. It does not say that you cannot speak to a juvenile during a Terry stop. If you're detaining a youth to dispel reasonable suspicion of criminal activity, you can talk to the juvenile. That's why the Terry stop is in place, is so you can dispel it or confirm it. Once, though, you've spoken with the juvenile, if you either develop probable cause or you somehow have managed to detain them, meaning you have taken them into custody of some sort, then you have to quit answering, put them in touch with an attorney. The best case scenario I see is most of you are investigating criminal behavior. And depending on how that plays out, I think you have a lot more room before you necessarily have probable cause than maybe you always think you do. If you want to get both sides, if it's an assault or some kind of he said, she said, you're still conducting an investigation at that point. So I don't think that you have to jump to PC any more quickly do your investigation. When you make the determination that you have probable cause, then you have to quit talking to the juvenile or put them in touch with an attorney. Once you have either placed them in custody or you are stating in your mind, I have probable cause right now to arrest them, that's when the attorney kicks in. Okay? Does that make sense? Good, because we just have people, our law enforcement's going crazy over this. Okay. All right, there's some exceptions to this, and this has to do with human trafficking, immediate threat or imminent threat to someone's life. So the best way I can think about it is if you know the student or the youth, planted a bomb or something that was going to kill someone, and you're not going to be able to put them in touch with an attorney because you're afraid the bomb's going to go off or something. If you think somebody's an imminent threat of being harmed, you don't have to put them in touch with the attorney, but you got to be able to articulate it. Again, more imminent harm. It's all about that, or if they're a victim of human trafficking. If you violate this statute, meaning you don't put them in touch with an attorney, the court's really clear they don't like you. So the statements are not admissible. The only exception is, and this is true even on the adult side, if a statement is involuntary or in violation of Miranda, it's never okay to lie on the stand. None of our constitutional provisions are going to be supportive of that. So if a youth were to go on, testify and lie, then that statement, which would otherwise not be admissible, could come in. If a juvenile makes spontaneous statements to you, that's all free game. Even if it's during the time that you're trying to get the attorney on the phone and the kid says, whatever, I can't believe I'm getting arrested for this, or, I know I did it, but why? Or anything. That's all spontaneous. So as long as you're not asking questions, all of that comes in. This came up, and I think it's been gone around all the prosecutors. The attorney can invoke for the youth. That's really clear in the statute, and the parent can. So what I've been told is that they put them in touch with the defense attorney on the 800 line, and then the attorney says to the kid, hand the phone to law enforcement. And the kid hands the phone, and then they say, he's invoking, and then it's over. And that's the intent, honestly, of the statute. Okay, I'm going to move on, but does anyone have any questions about that? Please don't be afraid to talk to them, especially if they're a witness or you're not sure. Because we have a ton of cases where I'm like, why didn't you just talk to everybody? And it's just like, I think there's a fear there, but I don't think it exists. There's a lot of good video evidence now. These kids are all over social media. I'm going to be really thankful that there was no social media when I was a kid. So do your preservations, do your warrants if you need them. For the phones, on all of that stuff. I just know that it's all out there, and these kids are posting so much stuff. They like to post confessions or videos of the criminal behavior. So there's a ton of stuff out there to get, but most of it's going to take a warrant. So, that's the other thing is you're going to need some help from law enforcement to get the warrants. Oh, and the recording. Okay, so now we're supposed to record as well. So, and they're very clear it applies to juveniles for any level of crime. So if you're at the point that you're advising a Miranda or you're obtaining a statement that's a custodial interrogation, they want you to record it. I didn't do the whole statute. It's actually quite long. But generally, you need to record it. Audio, video, if possible, at a minimum audio. If you don't, they want reports right away about why. You don't need consent. Because in my last year's presentation, it said youth refuses. And so I'm clarifying that this year. You can do your body cams. They can't stop you from the body cams. You just have to notify them they're being recorded. So what the provision here allows for is there are times when a youth might say, I want to cooperate, I want to give a statement, but I don't want to be recorded. And that's the exception they're talking about here, is if the juvenile would refuse to cooperate based solely on being recorded, you cannot record. You have to document that. What they're asking is that if you can get the juvenile to put that on a video, like, hey, I'm cooperating, but I will not be recorded, so that you have the juvenile's word that that's what they want to do. There are exceptions to the recording requirement. I don't know what feasible really means, but if you don't have recordings, I guess. But there's some shall if they're in a detention center. There's 060 is if the juvenile refuses but wants to participate. 070 is another jurisdiction, other state. If they comply with their rules, occasionally you won't know. I don't know if you don't know that they're a juvenile at the time because some of them tell you their age and they're not truthful, or you didn't know it was a felony on the adult side. If you have the safety of the officer, the person, or the CI, I can also see this in gang cases where they don't want to be recorded, and a malfunction of equipment. So there's exceptions. It's on the prosecutor who carries the burden of proving by the preponderance one of those exceptions if these aren't recorded. We have to file an intent and notice that we're relying on them. So if you don't comply with this statute, so if you don't comply with the attorney requirement with the juvenile, it's just out. If you don't comply with this statute, it's just one of the factors a court considers in whether or not to admit the statement. And they can, if the court admits it, they can grant the defendant an opportunity to present to the jury that you did not record the statement. And you should have. So just know that's there. So if you don't record for whatever the reason, it doesn't automatically kick the statement out the way it does if you don't put them in touch with the attorney.
Maybe we're at time.
Okay.
Want to go just a few minutes more?
Yes, I'm almost done, I promise, guys. Okay, drug possession laws. Everything's changed. I had to put in all the RCWs, but it's all the same as what was last year. So PCSs are pretty much gone. The first two law enforcement has to refer to services or treatment. You can refer past that too, 3, 4, 5. There's no limit on the number of times you could refer a PCS for treatment. But after 2, you can then refer them for criminal charges. The criminal charges are all misdemeanors at this point, for the most part. And so it also encourages prosecutors to divert them for treatment and rehab and all of that as well. So clearly we're taking a rehabilitative approach to this. I don't know on the juvenile side. I am shocked at the number of schools who are not doing anything with marijuana or even some of the other drugs. It is, I don't know, it's kind of crazy. But I get you have to refer for treatment, but you know, after 2, if you're referring for treatment and they're not getting it, they're not getting it. And so I think you got to look at something else. Most PCSs are now misdemeanors. The odd thing in this statute is that the criminalization of drugs expires on July 1st, 2023 if it's not amended. So then it's sort of in the negative. It's only here until then unless the legislature acts. So PCSs are subject to change again next year. This doesn't include PCS with intent to deliver or deliveries or manufacturers. So those laws all stay the same. Obviously, there's gray area between a PCS and a PCS with intent. But if you have a student who's giving them out at school, selling them at school, even if it's a few pills, that's a good wake-up call. I mean, just to be honest with you, because he's endangering other students, or she. So just be aware of that if they're dealing or giving them out, you can still do the PCS with intent. You don't have to refer for treatment. Okay, the upcoming laws that are on the hot topics is there is a move to not count any juvenile convictions in adult criminal history. It didn't happen this year, but it is still alive. And the other big Senate bill is expanding juvenile court jurisdiction to 18 and 19. Nobody would be ready for that. That would be a huge risk factor for detention centers, as well as treatment places. It would be kind of crazy, but these are the things that are on the horizon, which is also going back to our our state and especially our Supreme Court is much more protective of juveniles. So if you're going to err on the side of that. All right, so nothing's free. We pay to incarcerate, we pay to rehabilitate, we pay for CPS, foster care. Everything costs money. It's just where you want to spend it. And I really do believe in this. I mean, I do think we have to do more rehabilitative at times, but I get frustrated even in the juvenile court system of what we won't pay for, that nobody wants to pay for. And it's like, okay, well, we're supposed to help them. We're supposed to figure this out, and nobody wants to pay for things. So, and I feel like CPS and foster care are underfunded, so we expect them to work a lot of miracles too. So it's just kind of crazy. Our work is important. You're the first probably group of accountability that a youth is going to see, whether it's through the criminal system or school discipline. Like, that impact is significant, and it can, you know, it can be great, it can be horrible. Just try and always think of the best way that you can help. I'm constantly challenged by what we are allowing kids to live in and be raised in, and then expect them to somehow turn out miraculously different. But if you can have that positive impact early on, it's one person that's on their side. So that's always my pitch. Always call, email. I got emails last year after this. I will respond. This will be sent out. Any other questions? I'm sorry I went over.
Oh, no, you did great. Thank you.
Yep.
Appreciate it. Round of applause. Thank you.
Yeah,
Fabulous.
sorry.